Good afternoon. Welcome to the last session of our Agricultural Law Symposium. I'm Jackie Schweichler, a staff attorney at Penn State Law's Agricultural Law Center. If you've been with us since Tuesday, thanks for hanging out with us this week. If you're just joining us, welcome. I hope you've enjoyed the session so far, and if you're interested in joining us for future webinars, you can find the information on our website. Also on our website, you can find a ton of other resources on agricultural law and shale law. You can also subscribe to our Agricultural Law Weekly Review, where you will receive a once-a-week email with an updated list of the latest agricultural law developments. Or you can check out the Agricultural Law Tracker to find a timeline of updates on various ag law issues. Lastly, not lastly, I guess there's a whole list here, but you can also check out our virtual resource rooms to find compilations of resources on important ag law topics. Our website is brand new, so take note that our new URL is aglaw.psu.edu. That's aglaw, aglaw.psu.edu. From here, you can navigate to the Events tab at the top to find additional materials for this presentation and our other presentations this week. So if you've had some trouble finding the right forum for the right session, go to our events page. The forums are all listed there. And if you have any trouble with the code words, definitely send me an email after this and I'll get back to you as soon as I can. As we get started, there are a few logistics that I want to go over. First, take note that this webinar, like the other sessions, is being recorded. All attendees who registered for this webinar will receive a link to the recording in the next few days. The recording will also be able to be found on the events page of our website. The slides you see here have also been posted as a PDF on our events page. There are a couple I think that are still missing, but those will be posted within the hour following this session. If you have any questions today, please type them into the Q&A box, as you might have done already today, and we will do our best to answer them at the end of the presentation. If we run out of time, we will respond to you and your questions via email. Today's topic is pesticide drama and non-target liability. When we say non-target, we're talking about overspray or drift. And when I say pesticide, I mean both pesticides and herbicides. Throughout the presentation, I may just say pesticide to keep things moving, but understand that most topics will apply similarly to both pesticides and herbicides. So this non-target application or overspray or drift of certain agricultural products can damage neighboring crops. Lately, we've all seen Dicamba in the news, and much of this presentation was put together with that in mind. That's not to say that today's content won't apply to other types of pesticides or herbicides. In addition to Dicamba, I've actually had a lot of conversations with landowners about 2,4-D and ester formulations in general. In fact, I started working on this topic after I was put in touch with some local grape growers. While I usually work in State College, I'm actually from the Lake Erie region, so I grew up driving past fields and fields of grapevines. And before COVID hit, back when we were allowed to visit wineries, I talked to workers, and almost everyone I spoke to said that their grapes had experienced some form of damage from non-target herbicide application at some point or another. Part of the problem is that it's almost impossible to know how far a pesticide can move through the air once it's applied. There are a few studies that show it can travel up to 2 miles. I saw another study recently that showed esters could affect crops over 10 miles away. The idea, to me anyways, the idea that you can be liable for damages to property that's located even 2 miles away is kind of crazy to think about. And it's not just grapes. Tons of other vegetable crops and tree fruits are sensitive to certain pesticides, and it makes it very difficult to know what to do. So what are the current legal issues? Right now, pesticide issues center around applicator liability and products liability. I'll be discussing applicator liability, and Chloe will be discussing products liability. As we go through some of these topics, I'm going to talk about different options you may have as a pesticide applicator or as a landowner. This is not meant to be legal advice. Consider talking to your insurance advisor or attorney before making any business-related decisions. There are 4 main legal theories under which lawsuits can be brought against pesticide applicators for damages. A landowner whose property is damaged by non-target pesticide application could sue the applicator for strict liability, trespass, nuisance, or negligence. we're going to pay special attention to negligence as it's the most common theory used in these types of lawsuits. But first, let's discuss strict liability. You are strictly liable for an injury if you're involved in something that is considered inherently dangerous, or if the activity could be considered ultra-hazardous. If strict liability applies, the injured party does not need to prove that you were negligent or that you intended the injury to occur. A person can be liable regardless of how careful they were during the activity. For example, if a person is setting off explosives in their front yard and an injury occurs, they may be held liable under the theory of strict liability due to the ultra-hazardous nature of the activity. It doesn't matter if that person was very careful with their explosives. And when I say explosives, some of you may have thought about fireworks. Fun fact, there's actually a Pennsylvania case from 1960 that found that a public fireworks display does not fall under strict liability. As for private fireworks, who can say? Just an interesting look at what might be considered ultra-hazardous, and fireworks not necessarily. So food for thought there. The question here is whether pesticide application qualifies as an ultra-hazardous activity. In Pennsylvania, we don't have any laws that specifically define whether damages from pesticides count as a strict liability crime. Therefore, we have to turn to the courts to find the law. Here I've listed 3 cases where strict liability was used in bringing the suit to court. In Valari v. Terminix, the family had hired the company to spray a pesticide to help them with their termites problem. The family sued under strict liability relating to the applicator's liability and for products liability. The court found that the application of a pesticide within the home was not an ultra-hazardous activity. However, the court found that the pesticide was hazardous when inhaled, and the homeowners were not properly warned of that danger. If I remember right, I believe it was the labeling on the container that was insufficient as far as the warning goes. And a product may be found to be defective if it fails to come with warnings of foreseeable risks. So in this case, the application of the pesticide was deemed non-hazardous, but the plaintiffs were permitted to argue the product itself was hazardous, and so it still fell under the strict liability theory. The Valari case refers to the other 2 cases that are listed here. In Lowe v. Lenhart, the court found that crop dusting is an ultra-hazardous activity, and strict liability can apply. In Bennett v. Larson, the court found that pesticide spraying is not an ultra-hazardous activity. But note that neither of these 2 cases are Pennsylvania cases like the Valari case. In other words, a Pennsylvania court may look to these cases for inspiration, but it's not necessarily indicative of how a Pennsylvania court may actually rule on these issues. Sorry about that, some technical difficulties. So, what's the rule in Pennsylvania? Does pesticide application fall under strict liability or not? In the Valari case, the court said no, at least for applying pesticides. But they noted that under Section 520 of the Second Restatement of Torts, one of the factors in reviewing the ultra-hazardous nature of an activity is, quote, the extent to which its value to the community is outweighed by its dangerous attributes. For value, the court talks about economic benefits. In the Valari case, the plaintiffs are the ones who received the value from the pesticide application. Again, they had invited the company to spray for termites in their home. In other words, part of the reason that the court did not allow the plaintiffs to bring a strict liability claim was because they had invited this interaction in order to receive a benefit. It seems to me then that there's a real possibility of a different result in a non-target pesticide application case. If contact with the pesticide is not invited, so like an overspray situation, and the damaged person did not receive any value or economic benefit, then perhaps those factors could now support a charge of strict liability. So if these last 2 slides seemed like a lot of back and forth nonsense, let me give you the bottom line. At this point, we do not yet know whether non-target damage from pesticides would fall under the strict liability legal theory, but it could. If you're interested in this topic, our friends at the National Agricultural Law Center have put together a comprehensive document that compares landowner liability for non-target pesticide application. It compares all 50 states, and it's really interesting to see how states have addressed this topic across the US. All right, the next legal theory that you might hear in a pesticide injury case would be trespass. Trespass is the intentional physical interference with a person or property, or intentionally causing something to enter the plaintiff's land. If I walk onto your property, past your no trespassing signs, just to throw rocks at your house, I'm trespassing. If I'm your neighbor and I stand on my property and I throw rocks at your house, the rocks entering your property and breaking your windows constitute trespassing. In other words, a landowner who experiences pesticide injury could file a suit under the theory that a neighbor who sprays pesticides that enter their property has committed a trespass. All it takes is for the molecules of the pesticide to enter their property. Or, let me rephrase. All it takes is for the molecules of the pesticide to enter the property that belongs to someone else, and for those molecules to cause damage. Even if the pesticide applicator, never physically enters the other person's property, if your pesticides enter someone else's land and cause damage, that landowner could potentially sue for trespass. When it comes to nuisance, a nuisance is an activity that's designated as harmful or annoying. By definition, nuisance is the interference with a person's private use and enjoyment of their land. If you live in a college town, like me, you're familiar with noise complaints. That's nuisance. The loud music of the neighboring frat house interferes with my enjoyment of my property. I enjoy my property by sleeping there, or at least trying to sleep there. If an unwanted pesticide has damaged your property, then the interference would certainly disrupt the use and enjoyment of your property. And when we say the use of the property has been disrupted, that translates to the loss of any crops that may have died or been injured by the pesticide. And you could therefore theoretically bring a nuisance claim. Last but not least, we have negligence. The other theories we talked about are important to paint the picture of the issue, but they're not going to be the types of claims that the plaintiff's attorney adds to the suit as like the main. They're not going to be the types of claims that the attorney adds as like the main issue, right? These are going to be like an afterthought. These claims are more likely to be dismissed by the judge before the trial even starts. So what is negligence? Negligence is the failure to act as a reasonable person would act under similar circumstances. Was the person careless or thoughtless? Did they not do something that they should have done? Under this theory of liability, there are 4 factors that a plaintiff would need to prove. First, was there a duty? In pesticide application, generally, yes, the law imposes a duty on the applicator to follow the rules so that the pesticide doesn't spread to non-target areas. Second, and most significantly, is the question of whether there was a breach of duty. This complicates things a little in that we have to answer a second question. What is the standard of care? The standard of care is going to be what a reasonable person would do under similar circumstances. Did the applicator fail to act in a reasonable manner to prevent damage from the pesticide? If you aren't applying the pesticide according to the label, you're almost certainly failing to meet the standard of care. If you follow the label, but you don't apply your pesticide in the way that everybody else says is the safest way, well, you might not meet the standard of care. Did you check the temperature that day? The wind speed? Did you clean the tank and set the proper spray rate? Small mistakes can lead to big consequences. At the end of the day, the jury makes the decision on whether your actions were reasonable and whether you breached your duty of care. The last 2 factors are a little easier to explain. Proximate causation is about whether the injury is a reasonably foreseeable result of the defendant's misconduct. The keywords are reasonably foreseeable. If you apply pesticides in an improper manner, it's probably reasonably foreseeable that it could damage someone else's property. And lastly, actual damages. Did the pesticide actually damage the neighbor's property? Was there a value there that was damaged? If it kills off some grapevines, then sure, it's probably actual damage. But if the pesticide only hits some weeds in a field that they're not even using, maybe not. How much are those weeds actually worth to your neighbor, right? So if you're a pesticide applicator, or if you're advising a pesticide applicator, what is the best way to avoid non-target injury and potential lawsuits? Step 1 is to comply with all laws and regulations. This seems almost too obvious, but if you were found to have violated any laws, the claim is going to be negligence per se. Negligence per se is where someone violates a law that was written to specifically prevent the kind of damage that was caused by that person's conduct. The easiest way to think about negligence per se is with the car crash example. Picture the scenario where someone runs a red light or a stop sign and causes an accident. The law requires you to stop at a red light specifically to prevent accidents. So, by breaking that law and causing a crash, you're falling right into the definition of negligence per se. It's also important to note that compliance with laws and regulations includes federal law, like the Federal Insecticide, Fungicide, and Rodenticide Act, and state laws. Most importantly, you must follow the application instructions on the label. The label is the law. They say that a lot, and I'm going to repeat it again. The label is the law. If it says it on the label, you must do it that way. The label should have instructions on how to apply your pesticide in a way that reduces or eliminates drift or non-target application. If the instructions are written to avoid damage from non-target application and you do not comply with the instructions and damage occurs, the claim could be negligence per se. For the second point, remember that the law doesn't cover everything. You need to follow best practices, whatever those may be. Stay up to date on what works best. Talk to your neighbors, sign up for a newsletter, go online, find educational videos. It's up to you to find out the safest and most practical application methods. The idea here is that even if the law doesn't require you to do something, if there's a procedure that's considered to be an industry standard, you put yourself at risk if you ignore that procedure. Let's remember that farmers don't write the laws like politicians do. So you can't necessarily trust a politician to know the best way to apply a pesticide, right? So even if you do all the right things, there's still a risk. Unless you have no other farms in your area for 100 miles, there's a chance that your pesticides could end up on neighboring land. Depending on the situation, damages could be severe and costly. At the same time, insurance can also be expensive. Still, it's something to consider. You usually have to get insurance anyways. So check the insurance you have and see what it would cost to add this coverage. If you don't know off the top of your head, there's a good chance that your farm policy excludes pesticide drift from the policy under pollution exclusion or something like that. When you start looking into this, note that insurance companies may use the term chemical drift rather than pesticide drift or non-target application. And speaking of specific insurance terms, if your insurance coverage has a pollution exclusion, you should consider purchasing endorsements. An endorsement acts as a rider to your insurance policy. It might be wise to get a specific endorsement that covers chemical drift. It can't hurt to ask. A quick note for commercial applicators, general liability insurance pays the injured person for losses, but not the insured applicator. So if you are a commercial applicator, your insurance company will pay legal obligations, but take note that it will only pay for harms caused unintentionally. Maybe that sounds obvious, but it's something that you should be aware of. Again, commercial applicators, you also need to watch out for pollution exclusions that apply to pesticide drift claims. Continuing with exclusions, there's a little list here of damages that could be excluded from your policy. Just keep an eye out for these. First, your own farm and produce might not be protected. So if you apply pesticides on one field and it damages another field you own, you're unlikely to be insured for that. Second, if the damage occurs with intention, then your insurance company wouldn't pay for that damage. This is like what we just mentioned with the commercial liability insurance. The question here is what it means to intend. If you apply a pesticide on a windy day or one where you know there's a temperature inversion, that could be a factor. Third, insurance policies don't always cover injuries to people. If someone proves that your application of pesticides hurt them in some way, you would probably pay for their injuries yourself. Lastly, were the government to require testing or some version of environmental remediation, that bill might also land in your lap and not in your insurance company's lap. Last few notes that on insurance before we move on. As I mentioned briefly earlier, aerial pesticide application is often viewed differently in the eyes of the law. In other words, if you use aerial application methods, double check that it's covered under your policy. Next, if you get a claim, report that to your insurance carrier as soon as you can. Your insurance carrier is going to have a team who can document the evidence. If you don't tell them right away, you might lose your coverage. The longer you wait, the less evidence your insurance company can collect. If you delay unreasonably, your insurer could push back and may try to get out of paying anything at all. If I went through this insurance section too fast, or if you're looking just to read some more about it, the Grapevine published this article on liability coverage for chemical drift. It was published just a few months ago, so it should be relatively up to date. It's a good resource. As I mentioned before, the best way to protect yourself is to follow the letter of the law. Routinely check the Pennsylvania Department of Agriculture's website to stay up to date. On the PDA site, you'll be able to find resources on pesticide product registration, a ton of other things. All pesticide use in the United States is regulated under the Federal Insecticide Fungicide Rodenticide Act, or FIFRA or FIFRA, whichever. In Pennsylvania, minimum risk pesticides must be registered according to the Pennsylvania's Pesticide Control Act. You can find all that information and more on the website here. Now, if you're on the other side of the fence, this slide and the next are for you. I realize that I focused most of my presentation towards pesticide applicators, but if you're a landowner and you believe you have experienced property damage from pesticide drift, there are a slew of resources for you online. Penn State Extension has an article that I've hyperlinked here. It's called Herbicide Drift and Sensitive Plants, What to Do if Drift is Suspected. This is an article from Purdue Extension, and again, it's hyperlinked, so if you can just click on the link to read more. This article is called Options for Dealing with a Pesticide Drift Incident. These slides are available on our website, so if you're interested, check out the events page on our website, and you can find these slides and just click on it to get to these links. Now, if the worst comes to pass, and despite your best efforts, there's damage to a neighboring field, you still have non-legal options. This applies to both parties, the pesticide applicator and the injured landowner. The thing is, at the end of the day, no one wants to be involved in a lawsuit. Well, maybe some lawyers do, but otherwise, mostly no. The idea of a farmer suing their neighbor farmer, it kind of paints a sad picture, right? One thing that we can do to resolve the situation and avoid a lawsuit is we can go through the USDA's Agricultural Mediation Program. USDA has made available grants for state entities to provide mediation services for agricultural producers. As an agricultural producer or a farmer, you can request mediation for all kinds of issues. Almost anything relating to USDA, like agricultural loans or wetlands determinations. You can also ask for mediation over a leasing dispute or dispute with a neighbor. So if you're an agricultural producer and your neighbor is threatening to sue because they claim that your pesticides destroyed some of their crops, you could suggest mediation. So how does mediation work? After you call to request mediation, we hire a third-party mediator who helps facilitate a resolution to the issue between you and the other party. This is not a court case. This isn't a big legal soiree. If things don't work out, you can still file a lawsuit. So why would anyone bother to do this then? The main answer is that lawsuits are expensive. Look at the cost of the lawsuit and look how much you're hoping to recover. You have to pay your lawyers. But this program is currently free. Let's also note that it's hard to have a friendly relationship with someone after a lengthy lawsuit. With this program, you could come to a happy or happier resolution that might even allow you to maintain a civil relationship with your neighbor, a person that you're going to have to see at the grocery store every now and then. So to summarize, mediation is not a sure thing, but it could save both sides a lot of money and maybe save a neighborly relationship. As you may have realized from the slide headings, Pennsylvania does have an agricultural mediation program, and it just so happens to be run by Penn State Law's Center for Agricultural and Shale Law, us. And I guess they also, the program coordinator just so happens to be me. So it might be a little biased for me to mention mediation, but our program is growing and it's been pretty successful. And I'd really like to see more agricultural issues resolved amicably rather than through the courts. If you're interested in learning more about this program, send an email to agmediation@pennstatelaw.psu.edu or go to our website at www.paagmediation.com. You can also send me a direct email at jks251@psu.edu. And that's it for me. Up next Up next is Chloe, who's going to talk about ongoing legal issues for pesticides. Take it away, Chloe.
Thank you, Jackie. All right, so let me just share my PowerPoint. All right, Jackie, can you confirm you seeing my PowerPoint?
Yes, I see it. Looks great.
Perfect. All right. So there has been quite some drama around the three pesticides, the Dicamba, the Glyphosate, and the Chlorpyrifos, with many ongoing legal issues. So 30 minutes are obviously too short to go through everything. So I would like to focus here on the new EPA registration of Dicamba, the recent settlement agreement over some glyphosate claims, and the current state action for banning Chlorpyrifos, basically providing you with some clarity as to where things are at right now. Okay, so on the topic of Dicamba, like I just said, I will address the new registrations of 3 Dicamba products that were issued last October and their practical implications. But before that, I would like to provide some brief background so you can have a better understanding of the whole issue. So in early 2019, a group of nonprofits challenged before the Ninth Circuit Court of Appeals the conditional registrations of Bayer's products, Extendimax, BASF's Engenia, and Corteva's Fixapen that were previously registered by EPA in October 2018. According to this group, these restrictions violated the Federal Insecticide, Fungicide, and Rodenticide Act because EPA failed to meet the requirement whether the registration would not significantly increase the potential of unreasonable adverse effects on the environment. So the Court of Appeals agreed and vacated the registrations on June 3rd, 2020. The court found that EPA failed to demonstrate that the registrations of this product would not significantly increase the risk of any unreasonable adverse effects on the environment by substantially underestimating some risk that it recognized existed and entirely ignoring some other risks. As a result, and in compliance with the court-ordered registration cancellation, EPA issued a final order that retroactively revoked the product registrations to June 3rd, 2020. So although this order is now obsolete due to the new registrations, there may still be value for you to know its content. So I have included the details of this order in this slide. So EPA ordered that for parties in the distribution chain other than the registrant, existing stock already in possession as of June 3rd, 2020 may be distributed or sold only for the purpose of proper disposal or return to the registrant until July 31st, 2020. For commercial applicators distribution, existing stock already in possession as of June 3rd, 2020 may be distributed until July 31st, 2020. And use of existing stock already in possession as of June 3rd, 2020 is permitted until July 31st, 2020. So just weeks following this cancellation order, Bayer and BASF filed in July 2020 applications for new registrations of their products, Extendimax and Engenia, for new use on dicamba-tolerant cotton and soybeans. A month later, Syngenta also filed an application for a label amendment requesting to extend the upcoming December 20, 2020 expiration date for Tavium, which is another dicamba product. Just please note here that Fixapen was not the subject of a new application by Corteva. So EPA subsequently approved in October 2020 the registration of the 3 products for a period of 5 years. In a memorandum outlining the justification for the decision, EPA directs that the newly approved registrations are unconditional or for new use on dicamba, tolerant soybean, and cotton only, apply only in 34 states, including Pennsylvania, expire on December 20, 2025, prohibit soybean application after June 30 annually, prohibit cotton application after July 30 annually, require dicamba products to be tank mixed with a pH buffering agent, and that producers maintain a 240-foot downwind buffer and a 310-foot buffer in listed species locations. Require mandatory training on dicamba application, including equipment cleanout following the pesticide application, prohibit applications during temperature inversions and at any time other than between 1 hour after sunrise and 2 hours before sunset in order to address high volatility issues, and limit the state's authority to impose further regulations on pesticide use. So I would like to emphasize that latter point. Section 24C of FIFRA allows states to amend annually federal pesticide labels based on their special local needs, including agricultural, environmental, and/or public health needs, as long as the regulations are stricter than the federal ones. So over the years, states have often used this provision to expand or limit pesticide uses. EPA now stated in the footnotes of its registration decision that it is changing its interpretation of Section 24 and now imposes states to regulate pesticide use through state legislators or rulemaking procedures as set out in Section 24A of FIFRA. This new interpretation not only creates a burden on states as amendment procedure or less cumbersome than going through a rulemaking process, but will infringe on the state's ability to require additional restriction on pesticide use. So as might be expected, the new restrictions and EPA's reinterpretation of Section 24 triggered some legal challenges. And the first lawsuit was brought on December 21st, 2020, before the Ninth Circuit Court of Appeals by the same nonprofits that challenged the 2018 registrations. They asked the court to vacate the new restrictions, citing alleged violations of FIFRA and the Administrative Procedure Act. The nonprofits claim that EPA could not provide substantial evidence in reaching its decision, that the restrictions will not cause unreasonable adverse effects on the environment, and that EPA's refusal to go through the rulemaking process to alter states' authority to regulate pesticide use without holding notice and comment is flawed. In the meantime, the same four nonprofits filed a parallel lawsuit just a couple of days later, but this time in federal district court in Arizona, which mirrors more or less the same claims as the ones alleged before the Court of Appeals. Here, nonprofits argue that EPA failed again to fully consider the social and economic risks and costs to farmers posed by the new registrations. Another of their complaint is that EPA this time issued an unconditional registration for these products. Unconditional registration requires EPA to determine that the pesticide product operates properly without causing unreasonable adverse effects on the environment and performs its intended purpose as set out in FIFRA. But here, according to them, EPA allegedly failed to assess difficulty for farmers to both follow the label use directions of the products and control noxious weeds in the real farming world. So in addition, the nonprofits claim that EPA neglected to provide notice and an opportunity for public participation pursuant to FIFRA before authorizing a new use of the pesticide. And finally, plaintiffs state that EPA's blatant move via a footnote to get rid of state authority under Section 24C of FIFRA to further limit the use of pesticide is arbitrary and capricious and should have gone through the formal rulemaking process to change the rule. According to them, this change will impose further burden on the states while ignoring their special local needs in terms of pesticide applications. So for all these reasons, plaintiffs are asking the district court to vacate the new restrictions and stop the sale and use of the products. They also requested a court declaration that EPA violated Pifer and the APA for disregarding the state's authority over the use of pesticides. And we're now waiting for a response from EPA. Oops, sorry. Okay, so now the topic to the topic of glyphosate and the latest news regarding current litigation. So as you all probably know, Bayer announced on June 24, 2020, without admitting any liability in the lawsuits, that it is seeking resolution of approximately 75% of the current Roundup litigation, including claims filed as part of the Roundup federal multi-district litigation. Bayer estimated around 125,000 the number of filed and unfiled claims at the time it released its statement. In addition, the company also committed to establish a legal mechanism for the settlement of future claims through class action process. So in its 2020 half-year financial report, Bayer reported that it will direct $9.6 billion towards the settlement of all outstanding claims, plus an additional $1.25 billion to settle future claims. However, on July 6, 2020, federal judge Vince Chabria, who is in charge of the multi-district litigation, issued a pretrial order ahead of the settlement's preliminary approval hearing and expressed concerns over the constitutionality of the settlement. The proposed settlements involved the creation of a panel of scientists to decide in lieu of a jury whether exposure of Roundup is capable of causing cancer for future litigation. Judge Chabria wrote that he was, and I quote, skeptical of the propriety and fairness of the proposed settlement, and that he was more than likely to deny the motion for preliminary approval. As a consequence, 2 days later, Bayer withdrew its motion for preliminary approval while reiterating its intention of working to address the court concerns. So due to the current COVID-19 pandemic, Judge Chabria in July 2020 decided to stay the proceedings until November 2nd, 2020, in order to facilitate for the parties the finalization of settlement agreements, but directed them to prepare for trials as it did not intend on extending the stay. So to that end, 3 law firms representing some plaintiffs in the multi-district litigation notified last September the district court that they entered into master settlement agreements with Bayer. And considering the progress made, Judge Chabria allowed the stay of litigation to remain in effect until November 2nd, after which he said he would move cases to trial. So on November 9, 2020, Judge Chabria ordered trial to resume for a number of cases that are not subject to a master settlement agreement. And in a joint case management statement released last month, it was announced that 3,832 plaintiffs currently have pending cases before the court, of which 1,989 are subject to a finalized master settlement agreement. So in addition to the attention paid to the Bayer settlement, many eyes have turned to the resolution of 3 first glyphosate cases that have gone to trials that you all know as the Johnson, Ordeman, and Piliot cases. These cases are not part of the multi-district litigation and are currently being litigated on appeal. So about the Johnson case, as a reminder, the California First District Court of Appeals ruled against Monsanto and awarded last July Mr. Dwayne Johnson with a reduced verdict worth $20.5 million. Bayer filed a petition for review of the reduced verdict before the Supreme Court of California, but without success, as the court refused to hear the case. Now Bayer has until March 20, 2021 to file with the US Supreme Court. if that is why the company wishes to do. So now regarding the Ardeman case, the US District Court for the Northern District of California amended in July 2019 its judgment in favor of Mr. Edwin Ardeman and lowered the amount of damages awarded, going from more than $80 million to 25.3 million. Subsequently, Monsanto decided to appeal the district court's final judgment and also thought to reverse the reduced verdict, alleging that the district court made serious legal errors in awarding such amounts, especially as they argued that there is no present scientific evidence to suggest that glyphosate causes cancer. To the latest news, Ardeman filed a reply brief last August requesting the court to uphold the initial verdict of approximately $80 million and reverse the district court's amended judgment. Then finally, on the Piliot case, Alva and Albert Piliot filed last summer a reply brief asking the California Court of Appeals to reevaluate the reduced amount of total damages awarding to the couple in July 2019. The Piliots were previously awarded more than $2 billion in total damages, but the Court of Appeals lowered that amount to 87 million. Considering the reduced amount of total damages to be too little, the couple asked the court to reinstate the initial awarded compensatory damage, arguing that the court applied the wrong standard in appraising its amount. The couple also alleged that the punitive damages should have been reduced, and I quote, no less than 10 times the compensatory damages. As a result, the Piliot now demands the court up to $575 million in total damages. And in the meantime, the court is also hearing Monsanto's appeal of the case. All right, so I will now address the pesticide Chlorpyrifos and the state's current legislative and regulatory actions to prohibit its sale and use. But first, I would like to briefly talk about the current registration status of Chlorpyrifos with EPA. Yes. So while Chlorpyrifos has been banned for residential use since 2000 because of the associated risk posed to infants and young children, its use is still allowed for agriculture as a registered pesticide. Chlorpyrifos was last registered in July 2006 and is currently under registration review by EPA. As you all probably know, EPA has the responsibility to go through a review process each 15 years to determine whether the pesticide, in light of new information, poses health or environmental risk that may no longer be acceptable to the population. So according to the latest news, EPA informed in September last year that the agency has taken an additional step in reviewing the registration of Chlorpyrifos by issuing 3 draft risk assessment documents, a draft ecological risk assessment, a revised human health risk assessment, and an updated Chlorpyrifos refined drinking water assessment. And on December 7, 2020, EPA issued in the Federal Register a notice of availability of a proposed interim decision for Chlorpyrifos. The proposed interim decision proposes a series of mitigation measures to address potential human health and environmental risk that were highlighted in the draft risk assessments that I just mentioned. These measures include some label amendments, application restrictions, and spray drift mitigation. Comments on the proposed interim decision can be received until February 5, 2021. So these documents and proposed interim decision are available on EPA's website at the docket number here right on the slide. Okay, so following years of legal action challenging the use of Chlorpyrifos, along with the conclusions of many scientific studies that linked prenatal and early life exposure to the pesticide with neurodevelopmental conditions, EPA proposed in November 2016 to put an end on all uses of chlorpyrifos. EPA pointed out in its analysis that expected residues on individual food crops go beyond, and I quote, the reasonable certainty of no harm safety standard as set out in the Federal Food, Drug, and Cosmetic Act. However, this fell through after the Trump administration took office with former EPA administrator Scott Pruitt putting a stop to the rulemaking procedure. The restriction of chlorpyrifos is still being challenged in courts, but at the very moment, use of chlorpyrifos is still allowed. But in the meantime, some states have already taken legislative and regulatory actions against the use of chlorpyrifos, such as the states of Hawaii, California, Maryland, and New York. Actually, Hawaii became the first state in June 2018 to ban the use of chlorpyrifos. The use and application of chlorpyrifos are prohibited as of January 1st, 2019. The law, however, provides that the Hawaiian Department of Agriculture may grant certain pesticide applicators, upon request, a temporary permit to use chlorpyrifos until December 31st, 2022. Then followed the state of California. And on October 9, 2019, the California Department of Pesticide Regulation, which is a branch of the State Environmental Protection Agency, made a commitment to virtually end the use of chlorpyrifos in the state by February 2020. The department entered into an agreement with pesticide manufacturers to discontinue the sale of chlorpyrifos products on February 6, 2020 precisely. In addition, the agreement bans the possession and use of chlorpyrifos products by growers after December 31st, 2020. So California now is supposed to be chlorpyrifos free. So the state of Maryland also very recently adopted a phase-out plan to get rid of chlorpyrifos. On June 5, 2020, the Maryland Department of Agriculture adopted amendments to its pesticide use regulations with a phase-out plan that prohibits the aerial application of chlorpyrifos products as of June 15, 2020, and the use of chlorpyrifos or seeds that have been treated with chlorpyrifos as of December 31st, 2020. The State Department, however, still allows the use of chlorpyrifos or treated seeds for the treatment of snap bean seeds and the trunks and lower limbs of fruit trees. But the regulations specify that such use will be banned after June 30, 2021. And the State Department also may grant a temporary authorization to use chlorpyrifos for particular use and for a specified amount of time if there are no other available alternatives than chlorpyrifos. After December 31st, 2021, the state won't allow any exceptions to the prohibition. So now New York. In December 2019, New York Governor Andrew Cuomo instructed the State Department of Environmental Conservation to take immediate action to ban the aerial use of chlorpyrifos in the state and to develop regulations to prohibit all uses of chlorpyrifos by July 2021, except for its use on apple tree trunks. But more recently, Governor Cuomo signed into law on December 23rd, 2020, a bill prohibiting the use of chlorpyrifos on state properties, such as public parks, for example. The law precisely states that it is prohibited, and I quote, for any state department, agency, public benefit corporation, or any pesticide applicator employed thereby as a contractor or subcontractor to apply glyphosate on state property. The ban entered into force on the date of the law's signature. Some other states also are on the way towards a ban on chlorpyrifos use. Those include, but not limited to, the states of New Jersey, Pennsylvania, and Virginia. So in February 2020, a bill was introduced in the New Jersey Senate to prohibit the sale, purchase, use, and application of chlorpyrifos. So this bill still remains on the legislative session calendar for 2021, and if enacted, will become effective on the first day of the 7th month after enactment. There also has been a legislative attempt in Pennsylvania to stop the use of chlorpyrifos after the introduction of a bill in December 2019 that would have amended the Pennsylvania Pesticide Control Act of 1973 to ban chlorpyrifos, but without success as the bill later died in the House. Since then, there has been some talk, however, at the state level to prohibit the pesticide. In February 2020, it was reported that during a hearing on the Department of Agriculture's budget request, that the department made a commitment to consider whether banning chlorpyrifos in Pennsylvania is appropriate. The next month, it was also reported that the Pesticide Advisory Board within the department met to discuss potential legal actions to prohibit chlorpyrifos and sought information from stakeholders on their use of this pesticide. So finally, in the state of Virginia, a bill was introduced in the House in January 2020 and was designed to prohibit the manufacture, distribution, sale, and use of any chlorpyrifos product. The proposed bill also directs the Virginia Department of Agriculture and Consumer Services to remove all chlorpyrifos products. The bill also remained on the 2021 legislative session calendar. So besides these separate state actions, I think it is worth mentioning that here that a group of states that include New York, California, Washington, Maryland, Vermont, and Massachusetts are currently involved in multi-state litigation and are challenging EPA's refusal to ban chlorpyrifos despite alleged scientific evidence of adverse health effects on infants and young children. So the states filed in August 2019 before the Ninth Circuit Court of Appeals and were later joined by the states of Oregon and Hawaii as interveners. So the court agreed to hear the case and actually consolidated it with another case brought by a group of environmental organizations that were the same ones that previously challenged EPA's prior denial order to revoke chlorpyrifos tolerance and cancel all restrictions. To the latest news, oral arguments were held this summer, the case is still pending in the Court of Appeals. So as you can see, a lot is happening in the world of pesticides and more is to come, so stay tuned. We will make sure to provide you with the best information on these issues on our new website through the weekly review and issue trackers. But before we end this presentation, for those of you who would like to get CLE credits, the CLE code for this session is liability. Thank you all for your attention.
Okay, thanks, Chloe. Sorry, Jackie, didn't mean to jump in there.
No, that's fine.
Okay.
Go ahead.
So that was, so we had our first code word, which Jackie gave, and then that second code word again was liability.
Yes.
Correct? Okay, just making sure. And then look, Jackie, did you see, I got to double check on the questions. Did we have anything in the pipeline here?
We don't have any that haven't been answered yet. So we could, someone did submit a question a little bit ago and they asked, wouldn't another source of liability be the failure of someone applying pesticides? Could include another, an ag producer that may get into surface water to get a NPDES GP15 or individual NPDES permit from PADEP. Wow, PADEP. A lot of acronyms in that one. Yeah, and Brooke, you already answered it here, but I didn't know if you wanted to add a comment or two on that.
Okay, so in other words, the person was pointing out that, wouldn't it be good evidence of negligence that you failed to get a permit that you may have needed, which is, of course, yes. However, keep in mind that in cases of legal liability, in other words, civil liability, not like getting in trouble with DEP, regulatory liability, but civil liability to another landowner, for example, maybe, you contaminated their, well or something like that by, allowing this, the pesticide that you were applying to, enter, surface waters that somehow fed into their well. Anyway, the point is you need to have causation. So there's not it wouldn't necessarily be a given that you would have causation between the failure to have a permit and the actual incident that led to the contamination. So that can sometimes be a problem with, yes, the person who's alleged to have been negligent may have failed to do something they were required to do by law, but is there causation? In other words, did that in fact cause the incident or contribute to the cause of the incident? And, for the lawyers in the crowd, of course, we all know the wrestling of our lifetime when we tried to be taught proximate cause. So that would be an issue in that particular instance. But it's a very good point being made, which is that we didn't really talk too much about water contamination from pesticide drift. We talk about non-target injury to other plants and crops, et cetera, but we don't really talk about, water contamination, which is of course a completely legit and, potential risk, for pesticide applicators.
And if I can just contribute as well, I mean, I think the question raises a good point and kind of raises that distinction of civil liability versus regulatory responsibility or being the subject of some type of enforcement action. And our discussion was focused on the imposition of civil liability, and certainly there is the whole discussion of responsibility for violating regulations, which I think is, like you mentioned, Brooke, really it's an important topic, is another topic that's raised by this set of facts.
Right. And Chloe, I just want to make sure I think we are at the 3:15 mark. I just wanted to make sure I'm thinking back through. Did you mentioned, I believe you did, the Dicamba settlement that was finally made public recently with the website where other soybean growers who have been who planted Dicamba or didn't use Dicamba tolerant soybeans are damaged by their neighbor who was applying Dicamba to his Dicamba tolerant soybeans. So that settlement, while there has been now finally a claims process for soybean growers who were damaged by Dicamba drift because they were not using Dicamba tolerant soybeans, there hasn't been any discussion whatsoever yet to confirm that there is any settlement in the works for grape growers or peach growers or other crop growers who have been damaged by Dicamba. So that's a big thing that's hanging out there that we're not hearing any news on. Yet when they announced in June that there was that settlement, everyone was led to believe that that would be part of the settlement, that it wasn't just going to be for a settlement for other soybean growers. So that's kind of a loose end here that we're really, looking at. That's what's going on. A lot of silence from Monsanto. As Chloe well knows, trying to get information from their website about in their press releases, you just get nothing from, they're very tight-lipped about all of this. And, they want to get the public relations that there's been settlements and that they're paying up, but getting the information is another story. So in any event, just wanted to add that.
Well, we're at, I guess 3:17, so 2 minutes past our time. And I wanted to thank all of the attendees for joining us. We hope that you found all of the presentations to be of value. If you have any questions at all, or if you have any feedback that to provide to us as to how we can topics that you would like to see in the future or things that we could do to improve the educational experience, please let us know, because we have used webinars and we do plan on continuing to use webinars and continuing to offer continuing legal education credits as well. So with that, again, thank you very much, all of you, for attending, and we wish you a good afternoon.